Report. I'm your host, George Walden, and in today's episode, we're diving deep back into the world of standard essential patents, or SEPs, under the new framework of the UPC. As industries continue to evolve and intertwine through technology and innovation, SEPs have become pivotal in the implementation of standardized technologies, such as those found in telecommunications and computing. I'm excited to welcome back Julian Würmser, as he promised us to come back on the show when there was more movement and rulings concerning SEPs. And also, we're excited to welcome our first-time guest, Moritz Bloser. We have two distinguished podcast guests who are very well respected in their fields of expertise to our UPC Insights show today. But before we get started, as always, let me give you a little background about our two guests before I introduce them. First, first, the incredible Mr. Julian Würmser. He is a renowned patent advice attorney in all matters of intellectual property law, in particular patent, utility model, trademark, and design law, employee intervention law, support and opposition, utility model cancellation, design cancellation, and nullity proceedings, enforcement of intellectual property rights, for example, in patent infringements, actions, or arbitration proceedings, and preparation of expert opinions, freedom to operate, negotiation, and drafting of development of license agreements, and current lectures. Ladies and gentlemen, please welcome to the UPC podcast, once again, the incredible Mr. Julian Würmser.
Thank you, George. You are always so kind. I feel like I'm 7 feet tall now.
Yeah,
Thank you very much.
You're more than welcome. And now it gives me great pleasure to introduce our next distinguished guest. He is Moritz Bloser, who has a wealth of knowledge and experience. Moritz has been admitted to the bar in Germany since 2012. He advises national and international clients on all matters relating to patent and utility model law. He specializes in patent infringement litigation, especially in the fields of mechanical engineering, medical technology, mobile communications, telecommunications, and electronics. In the fields of mobile communications and telecommunications, he has extensive experience with standard essential patents, SEPs, and the related antitrust and competition law issues, FRAND. In this area, he also frequently advises clients in cross-border patent disputes. In addition to this focus on patent litigation, including freedom to operate and infringement opinions, Moritz also advises on contractual matters such as license agreements. Furthermore, he advises clients on the analysis of their patent portfolios and the development of individual patent strategies. Ladies and gentlemen, please welcome the one and only Moritz Bloser. Moritz, how you doing?
Thank you very much. What a great welcome. I'm good.
Great to have you guys here. Hey, I have a first question, and this goes to Julian. Last time, remember this, you've been in our podcast, you already provided some input on standard essential patents, SEPs, and you mentioned that the important decisions about where about to come out at the UPC. Now we have finally have the first UPC decisions concerning SEPs. As I understand, this decision was actually not expected to be given anymore. What happened?
Yeah, George, actually, this is an excellent question. So the situation was like we were all waiting for first decision at the UPC to come out regarding FRANDs, so fair, reasonable, and non-discriminatory licenses. And then the parties actually settled. And so we were all, oh God, now we still have to wait another half year until any clarity comes around. So, because you understand, like, I mean, the UPC court, it's a fresh court. We need decisions, decisions. And as long as we don't have decisions, there's no clarity for the users. So the court is not that attractive. And but what happened, although the parties settled, in this case, it was Panasonic and Oppo, their settlement declaration sort of, or maybe not even a complete settlement happened. And so the local division of Mannheim actually took the chance to give the first official decision on FRAND and FRAND licenses, which from our perspective is a super good thing. And that kind of makes today's podcast possible. So we actually have some additional clarity on the matter.
That sounds pretty good. So last time we already talked about FRAND, the license terms which are fair, reasonable, and non-discriminatory. You already explained that the so-called FRAND dance which is based on the framework as set up by the European Court of Justice in the Huawei versus the ZTE decision in 2005. As I understood it, there's a particular order that the parties have to follow to use the so-called FRAND defense in a litigation case, zum Beispiel. As I understood it, the German courts have developed their own procedure to deal with FRAND and German infringement proceedings. So, how did the UPC implement the FRAND dance?
So I think this question is for me. Maybe just a little recap on SEPs and FRAND in general. So the situation is that you have a patent owner who is the owner of a so-called standard essential patent. This means a patent which is part or which focuses part of a standard like a Wi-Fi standard or LTE standard. And this means that you could, with the only single one patent, you could bar anyone from using, for example, Wi-Fi. And since this is not acceptable on competition law aspects, the so-called FRAND was developed. So this SEP holder has to give anyone who wants it a respective license under FRAND terms. So this fair, reasonable, non-discriminatory terms.
Wow. So what exactly is FRAND in the accordance with the UPC then?
Yes. So we
need to stop here.
Okay.
So, ich meine, Moritz, kannst einfach weitermachen aus meiner Sicht der.
Okay.
So you have to give Moritz a little bit more time.
No problem. I didn't know with the break if he meant.
No, he's not finished. So Moritz, du kannst einfach weitermachen, dann schneidest du das nach. Und deine
Sorry
Frage,
about
George,
that,
kommt erst, also quasi nach einer langen Pause von Moritz, kommt deine Follow-up-Frage, George. Okay?
Yep.
Good.
Okay, jetzt mal kurz.
Should I start the whole question again for you, or?
Nein.
Okay.
So this means we have two parties. On the one side, the SEP holder, and the other side, the potential infringer, the person who's seeking a license. We call him the implementer. And now they're facing each other potentially first in negotiations, out of court negotiations, and then later, if this is not coming to a conclusion, in litigation. And to find this FRAND dance, a balance between the parties, the European Court of Justice, like we said before, developed this framework. This framework has essentially 5 steps. First one is the infringement notice by the patent holder. So he needs to let the implementer know that potential patent of his is infringed. Secondly, the implementer needs to express his willingness to take a license. The third step is the FRAND offer of the SEP holder. And if this offer is not acceptable to the implementer, he can make a counter offer. And if this counter offer is refused, he has to provide security. These last 2 steps are not so relevant in this case or for our assessment right now. But so now in this FRAND dance, we have a lot of national case law. From most of this is from the German courts, but also from the UK courts and Dutch courts. And now for the first time, the UPC has rendered a FRAND decision.
Okay.
In general, we can say that the findings and decision and their interpretation of the FRAND dance is a mild variant of the German Ciswell higher case law, so the case law of the German Federal Court of Justice. In general, it can be said that they found a balanced approach between the SEP holder and the implementer, giving both sides high demands on how to act responsible within this framework as explained. Like in the first step, we said it's the infringement notice. There's not too much sorry,
no problem.
For the first step, the infringement notice, the court does not take a very formalistic approach and makes not too much demands on the SEP holder. For the second step, the willingness, here the court takes an overall assessment, evaluating the conduct of the implementer towards the SEP holder, and not only at the beginning, but for the whole proceedings. For the license offers, which you said the next step is the license offer of the SEP holder and then a potential counter offer. Here we have a little variation towards the German case law, because the UPC will assess both offers whether they are FRAND or not. So they are in line with these fair, reasonable, and non-discriminatory terms, license terms. The German courts, they had a little other approach. If the counteroffer of the implementer was not FRAND, then it was not necessary for the courts to have a look at the initial FRAND offer of the SEP holder. This is now a little different. They take every single step more individually. In all, for the negotiations between the parties and the ping pong between the separate steps, the UPC now takes a more practical approach. So they take emphasis on the customary business practices for license negotiations, and that the parties conduct each other and themselves accordingly. So for the infringement notice, it is usually deemed sufficient to provide, to name the individual patents and provide claim charts. For the counter offer, for the FRAND offer of the SEP holder, the court does not deem it necessary that already in the first step the SEP holder provides a ready-to-sign full-fledged license agreement, but rather it is sufficient to have the relevant economic terms which are important for the license agreement. This also may be a little different to the approach of the German courts. They have a higher bar for this license offer. What's very important here for the court, which puts emphasis on several parts of the judgment, is that if the implementer has misunderstandings or problems with individual aspects of the, for example, the infringement notice, or of several terms or aspects of the license offer, it needs to immediately and promptly address such misunderstandings. So the implementer cannot wait until the potential litigation, the later stage, and then point out, yeah, this was wrong and this was wrong, and therefore there's was no correct infringement notice, or the license offer was not FRAND because this license term is not FRAND. So the implementer always needs to address everything immediately. It's not sufficient to only address this in the litigation for first time. Yeah, and that's in a nutshell is the main and most relevant aspects of this new UPC decision.
Okay. So then that brings me to the next question. So what exactly is FRAND in accordance with the UPC?
Yeah, here actually there's no surprise. The same as the German courts, also the most of the European courts, they deem that FRAND is a range, a corridor. So there's not a single individual FRAND rate. So let's say 50 cents per device, but it's always a corridor. So a range of potential FRAND rates, which can all be FRAND.
Okay.
So rates. And what's interesting is that the court makes points out that the SEP owner is not required to offer the lowest rate in this corridor. So if he has a FRAND rate within the corridor, in the middle or in the higher range, this is acceptable. This is still FRAND, and the implementer cannot require that he gives him the lower rate within the corridor.
Okay. In preparation for this podcast, you said that the OPPO pulled a particular strategy to defend themselves against the infringement allegations of Panasonic. What was that about?
Yeah, that's a fantastic question, George. So think about it like this. First, you have this negotiation, the SEP negotiation, and you're supposed to behave in a friend manner. And at some point, you as the SEP owner, you have the impression the other side, the implementer, is not behaving how he should. So you start
Okay.
to sue him. And then while you're in the court action,
Mhm.
there's this new tool. And so the new tool basically says that the implementer, he actually starts his own action. In our term, it would be a counterclaim for determining a friend license. So what he's essentially trying to establish, he
Yeah.
is trying to force the court almost on a declaratory basis to give you the license the implementer thinks he is entitled to. And this tool is quite heavy. It's
Yeah.
quite interesting. And at the beginning, it was actually there was a big question raised, at least by Oppo. They tried to defend themselves
Mhm.
with this counter action. And Panasonic at the beginning basically said the UPC cannot handle these types of counter action. And so we also got some security on that matter. And Moritz is going to evaluate a little bit on this.
Okay.
Yes. So as you know, the UPC is a patent court. So the question was raised whether this mere competition law issue
Mhm.
can be heard by the UPC. But the UPC says it's competent to hear front counterclaims or front claims because they are also in response to the patents themselves, the SEPs. So they have this, they call it an anchor. The patent is the anchor for being competent to hear competition law aspects.
Okay.
So probably a singular friend complaint might not be possible, but we don't know yet. So yeah, the court decided that the counterclaim as filed was in general admissible, but in the end they decided it was unfounded. The Oppo here asked the court basically for three different things. It was an auxiliary matter. They had a first claim and then auxiliary rise. They cascaded further potentially claims. The first one was to require that Panasonic has to accept Oppo's license offer, which was provided together with the counterclaim. This was obviously reduced in the complaint, so we don't know any specifics, but they made a further counteroffer and asked the court to force Panasonic to accept this. This was then also that in the first step they had that the rate would be between this and this amount. We don't know the amounts. And another one was to determine a lump sum payment. And at the third step, they asked the court to themselves determine a potential friend rate, which then Panasonic has to accept. In the second alternative, they asked the court to force Panasonic to themselves, that Panasonic has to submit a specific offer to Oppo, again, based on certain friend rates or a rate to be determined by the court. The first one, the offer which Oppo provided and was asked to that Panasonic has accepted, this was already dismissed because the court was of the opinion that Oppo's offer was not FRAND. Lastly, they also asked the court for a declaratory judgment confirming that Oppo has the right to a license from Panasonic. This was also not decided because the court found that Oppo has no legal interest to ask for such a declaratory ruling, because in the other two claims, they ask for a positive ruling, like they have to accept our license or they have to provide a license. So there was no need for a declaratory ruling. The main problem with the claims Oppo made and the respective license that they asked for was that they only asked for a license in the UPC territory and in the US and Japan, but not for a worldwide global license. And there the UPC said, no, that's not possible. SEP license negotiations with portfolio license, they are always global. That's customary in the business practice that you always have a global FRAND SEP license. So Oppo would have needed to ask for such a global license. Two another interesting facts are that the UPC also found that it has not the power to force an SEP owner, as Panasonic, to accept an implementer's license. This would not be possible. And another thing what the UPC left, unfortunately, open, would be interesting is if we have, like we said before, we have first we have the FRAND offer of the SEP owner, and then a potential counter offer of the implementer. And as we said, FRAND is a range, so there's a possible situation that both offers are within the FRAND range. Yeah, potentially the offer of the SEP holder is a little higher, and the counter offer is a little lower, but both are FRAND because both are in the range. Then it's the question of if in such a situation the UPC could determine a specific FRAND license range within the range between the parties. But this was not decided here, and we don't know yet. But this still remains a very interesting potential topic for a future case.
Wow. Okay. Well, then, so looking at the whole subject of SEP at the UPC, what are we expecting next? I mean, this seems kind of wild, wild west like out here.
George, it's not. From our perspective, it's all running in defined paths.
Okay.
But I mean, as said, it's a new system, and so many things are open. So one thing we are of course expecting currently, Moritz already mentioned this, like the UPC, also with SEP and FRAND rates, they are taking a somewhat German approach here, and so what's going to be very, very interesting to learn is this is all first instance decisions. Will this trend uphold in the second instance? So that's something we are really keen on learning. Another bit is, and I mentioned this in our last conversation already, originally we were kind of expecting that the UPC would be the court to go to when you're an SEP owner.
Yeah.
And from my perspective, this has not really happened yet. So, I mean, it's visited quite frequently by SEP owners, but it's still not the top court, or at least we would expect more traffic. And so we are kind of interesting to learn whether this decision is the trigger to kind of start maybe even more engagement. And also what's kind of interesting, Great Britain and the British courts, they have been quite active on the SEP matter as well. And so we are quite interested in learning how kind of these courts will kind of bear to a certain degree in competition. And so which of these courts will in the end be the preceding court, the first court? And so that's another matter that, as said, like, I mean, the field is open and there's quite a bit to find out.
Yes, but in a nutshell, one can find that this decision was at least not unfriendly to the SEP holder. Yeah, so it makes it attractive or not less attractive to go to the UPC as an SEP holder and try to enforce their SEPs, and not too much surprise. But as Julian said, it's one decision of one court, first instance court. We don't know how, for example, the Munich local division will see this aspects and this FRAND defense steps. And also, like I said, this case is almost settled or is already settled, so there's potentially no appeal proceedings here. So we won't know how a court of appeal would see the findings of the Mannheim court. So it stays interesting.
Okay. Well, then, I mean, that's a lot to take in, but also we have a better insight of everything. And I want to take this time, because we got to wrap it up, to thank Julian Würmser for coming back, because I know your busy schedule and you promised to come back, and I know your schedule is pretty busy. So thank you for getting here and coming back with us. And also thanking Moritz thank you for joining us for your first time there. And I hope you have time in the future maybe to come back, like Julian, to discuss some new topics with the UPC in the future. And we have a lot of great UPC Insight content from the past shows that are more relevant and exciting than ever. And we urge you to check them out on our YouTube channel or our website at meissnerbolte.de or meissnerbolte.com. If you have any questions or any UPC Insight topics for any of our guests here today that you would like to talk about, please feel free to contact us. Until then, see you soon und auf Wiedersehen.
Thank you,
Vielen Dank.
George.